And I'm Judge Monica Purdy, the judge of the 95th District Court. We are set this morning for a status conference. The cause number is DC 20-17379, Daryl E. Blair Sr. versus Deborah Blair Abron. Is Mrs. Abron or Mr. Blair going to be present this morning at the status conference?
Mr. Blair will not be present. I was not aware that we needed to have the individual parties here for this hearing.
Okay, and the court was not asking because we require their presence. I just wanted to know if we had everybody we needed to have on this particular hearing in order to proceed.
Understood, Your Honor. With respect to Ms. Abron, I do not know if she will be joining. She is so far been pro se. She actually has not filed an answer in the case. She did appear in person for the temporary injunction hearing, and I've had some communications with her, but it's been difficult. Half the time her emails bounce back or like I get her voicemail. But I know that she did receive notice of this setting, and she received the Zoom information. That said, I think I can probably adequately update the court if you want to just go ahead and proceed.
Sure, let's go ahead and proceed. We're set for a status conference. The court has reviewed, I guess, the letter that you sent to the court on December 29th, sort of outlining where you are in terms of mediation, identifying mediators. So let me know if a mediator has been selected and when you all are scheduled to mediate.
Yes, Your Honor. First of all, just as a slight aside, I'd like to say congratulations and welcome to a new bench.
Thank you.
Glad to have you. So as the letter indicates, we had suggested 2 mediators. Ms. Abron did not say that she was not willing to use them. She turned around and suggested an additional mediator, a retired judge,
Mrs. Mary Ellen Hicks.
Yes.
Correct.
And she provided me with a phone number to contact Ms. Hicks. I have called a couple of times and not been able to get through. I'm receiving a message saying, this wireless caller is not available at this time. Call again later. I've tried to reach out to Ms. Abron to see if she has additional contact information. The concern that my client has is Ms. Abron has sort of given the indication that she does not intend to hire a counsel or to essentially spend $1 on this case. And he's got concerns about her being willing to pay her share of the mediator's fee. And so I'm trying to bring that issue to a head by selecting one, establishing what the fee is, and then allow her to decide whether or not she's going to do it. If she is, my client's absolutely willing to mediate. To give you just a little bit of background, the other issue that's here that you've always kind of got in a situation where you've got somebody pro se is we're playing a little loose with some of the rules and formalities. Basically what is at issue now is during the TI hearing, Ms. Abron brought in some documents to try to establish that my client does not own Elite News, the newspaper, and therefore doesn't have a right to exercise intellectual property rights over the trademarks. The court agreed that even if that were the case, those marks go with the paper, and that doesn't give her the right to unilaterally go off and use them in competition with the paper, and that's the way the TI is written. The concern and issue that we have is that she hasn't filed an answer. She hasn't filed any defenses, or arguably what I think she was trying to argue was maybe a counterclaim that she has some ownership rights to the paper. None of that is in front of the court at this point. Presumably that's what we would be mediating. So there's a little bit of a cart before the horse situation.
She didn't file an answer, but she did appear in person, correct?
She was here in person for the TI hearing. So
okay.
We didn't move for a default or anything. Again, we're not trying to, use a technicality. But the court essentially decided that, he thought it was a family dispute and thought a quick mediation would be helpful. And that certainly may be the case, but again, only if Ms. Abron is willing to, obviously pay her share of the fee. The other final issue that my client has is with respect to whoever's going to mediate it. He has concerns about obviously the suit itself is public knowledge, but it's a small community among retired judges and those that associate with the Elite News, et cetera. And he wants to ensure that we use a mediator that's a stranger to the parties. He doesn't want the family's internal conflicts to be, fleshed out to yet another person that, already has some connection to the family. And from my understanding, the two mediators that Ms. Abron has suggested so far have very direct connections. And so depending on what Ms. Hicks' fees and availability are, my client would still probably like to use someone that is a stranger to the parties entirely. And I don't believe Ms. Hicks would qualify under that. So that's the one thing I would preview, is that there's a chance that we may not use Ms. Hicks, even if the fees are agreeable and schedule, just because that's a very big concern for my client.
All right. I see that an alternative mediator, former Judge Marty Lowy, has been identified as a possible mediator.
Yes, I suggested Judge Lowy as a potential mediator, as well as John DeGroot, and this was right over the holidays. So a few of the others that I tried to contact, I was not able to get information back from. I have received return calls from Jeff Abrams' office and Jeff Kaplan as well. I need to get their rates and schedules up, but they have called me back. So there are other alternatives that I think would work.
Okay. So let me ask you, during the temporary injunction hearing that you all had, was that hearing recessed and you all were ordered to mediation, or was there an order entered?
There was an order entered. So there was initially, we had the TI hearing, I think on December 8th, via Zoom. Ms. Abron showed up in person about 10 minutes into it, right as Judge Lee was about to issue the TI, and brought in some documents that I was unable to see because of the technical difficulties. So he recessed that hearing and allowed us to do a little bit of a quick document exchange. And then we came back on, I think it was the 21st or 22nd. And during that hearing, he actually granted the temporary injunction and entered it. And essentially what it says is that neither party is allowed to use the marks in competition with the newspaper. And so Ms. Abron has taken down her website at this point. I don't believe she's sending her email blasts anymore. So far we've been comfortable that she's complying. But yes, to answer your question, I'm sorry, it's a long answer. To answer your question, yes, there is an actual temporary injunction that has been entered. The mediation piece of it was in addition to.
Okay, all right. Well, I want to make sure that this continues to move on. I know that you mentioned there were two other mediators who had gotten back with you, but you don't know their fees as of yet.
Yeah, I got voicemails from their assistants calling me back from the messages I left over the holidays. So I will need to circle back with them.
Okay. What the court would like to happen is that you update me with those other two mediators that you have mentioned here in this particular hearing, their names and the fee that they would charge per side. And the court is inclined to go ahead and select a mediator, since obviously there is some type of issue as to coming to an agreement as to whom you should use. The court will sign an order to that effect, saying that mediation must take place by this particular date.
Okay.
Okay.
And when would you like me to provide that update?
If you could provide it as soon as possible, make sure that is it Abron or Abron? I'm not sure if I'm pronouncing that correctly. Make sure that she is copied on that letter. I know that this particular letter that I have reviewed from your office, Mr. Cronin, is dated December 29th. It appears to send her an email. I know you mentioned that you've had some problems with bounce backs. Do we also have an address for Mrs. Abram?
I do have an address.
Okay, I would send it every way you know how to send it to her to make sure that she has received it. And once I receive that, I'll give you to the end of the week till Friday to sort of update the court with that particular information. And then the court will push out an order to the parties, basically deciding who's going to mediate this case and by what day it needs to be done. Now, I will just provide in that order a drop dead date as to when the case needs to be mediated, but it is the intent of the court for you all to confer as to when might be a good date for you all to mediate the case. I'm just saying it has to be mediated by this date.
Understood, Your Honor. And with respect to that order, would you like a proposed order, or are you simply going to craft that one?
You can upload a proposed order to the court's filing and just leave the information for the mediator for the court to input that, as well as the date.
Okay. And then the other two questions with respect to that order, one, would it be acceptable to have the order expressly state that the parties have to each pay their own share mediation fee? Okay.
Correct.
And then the follow-up question to that is, if my concern about Ms. Abram refusing to pay her share of the mediation fee is true, would it be proper to have language that states that if either party refuses, that the requirement to mediate is?
I haven't, let me just say, I have not taken a look at the temporary injunction order that was entered. But if what you have represented to me, that mediation was a condition of that particular order, then if someone is violating the order, they could possibly be in contempt of the court's order. If that should answer your question. I haven't taken a look at the language. I only took a look at the update on December 29th, and I have a copy of the temporary restraining order, but not the actually injunction. And I can go back and take a look at that, but I would just track the language in that temporary injunction order.
Okay, I'm taking a look at it now. It states that in lieu of status conference, the parties may submit in writing a joint declaration that they have scheduled mediation but have not yet conducted the mediation, in which the parties propose a setting for trial of this cause. So it doesn't, I guess it doesn't mandate it, but I'll let you take to look at it to I guess how you read it. But we're fine to mediate. I have a feeling I know what's coming, and I just want to make sure that we don't get stuck spending a lot of time and energy and money trying to force this mediation. If it's not going to happen, I'd rather move into discovery and
yeah, I mean, it's the court's intent that everybody pay their own share of the mediation expenses. And if that doesn't happen, then obviously the next default under a TI is we get you ready for a trial date and we get this moving as it is set for trial.
Perfect. Thank you, Your Honor. I appreciate it. Is there anything else that you need from me today?
No, there's nothing else. Again, I'll just make a notation that you'll have a letter to the court, much like your December 29th letter, with an update as to those other mediators, as well as the rate that they charge. And you'll have an order that is uploaded by that particular time. Just again, make sure that we are noticing Mrs. Abram every way we know how. And it's the court's intent to continue to move this case.
Excellent, Your Honor. Thank you. And again, congratulations.
Thank you so much. Take care. Bye-bye.